Welcome back to The Explainer. Today, we're diving headfirst into a true crime story that is, frankly, wild. We're talking about a landmark 2002 judgment from South Africa, Phoebus Apollo Aviation versus the Minister of Safety and Security. It's a case that perfectly illustrates a super complex area of constitutional law. Basically, we're going to explore exactly where the state's responsibility begins and where it ends when its own agents go completely rogue.
Picture this. It's the ultimate betrayal of public trust. A perfect crime, but pulled off by the exact people sworn to stop it. The unbelievable facts of this case kick off in November of 1998, when an armed gang broke into the home of the controlling member of an aviation company called Phoebus Apollo, located in Midrand, South Africa. The gang made off with a massive sum of money. Now, the company was obviously devastated, but they held out hope. They figured the authorities would track down the culprits and get their stolen property back. And well, the authorities actually did track down the money, just not at all in the way anyone expected.
Okay, let's dive into this timeline, because the sequence of events here is just incredibly audacious. After that November 1998 robbery, the official police investigation slowly grinds forward. Fast forward to mid-January 1999. The official investigating officer finally gets a break. He traces a portion of the stolen loot to the home of the father of two of the robbers, up near a town called Tsenin. So the investigator travels all the way out there with an informer to recover the cash. But when he arrives, the money is already gone. Why? Because exactly one day earlier, 3 rogue police officers had somehow gotten wind of the money's location, driven up to Tsenin, and intercepted the cash themselves. The real investigator was quite literally scooped by his corrupt colleagues.
Now we really need to look at the specific, shocking details of this secondary heist. These 3 officers had absolutely nothing to do with the official Midrand robbery investigation. They were stationed in completely different areas, Alexandra and Rosebank. But they decided they wanted this loot for themselves. They drove up to Tsenin in a marked police car, they confronted the father of the suspects, and crucially, they used their official authority, their badges, and the sheer weight of their uniforms to demand he hand over his son's hidden cache of money. They created a complete, total facade of official police business just to steal the recovered money for their own pockets. And spoiler alert, none of that money was ever seen again.
So this brings us to the central question of our explainer today. If cops, using a police car and police authority, literally steal your money, does the state have to pay you back? Phoebus Apollo Aviation understandably felt that, hey, since police officers took the recovered money using state resources, the state should reimburse them. So they sued the Minister of Safety and Security. And this is where our narrative pivots, right from a shocking true crime story directly into a deeply complex legal conflict. Let's see how this builds into a major constitutional showdown. The aviation company, deeply and rightfully frustrated by losing their money, not once, but twice, took their fight through the legal system. They pushed and pushed until they eventually found themselves standing before the highest court in the land, the Constitutional Court of South Africa, in November of 2002. They were demanding their money back from the state, arguing that the Constitution itself guaranteed their right to a remedy. To understand this battle, we need to clearly define the legal battlefield we're on. The big concept here is vicarious liability. In common law, this is the principle of holding an employer legally responsible for the wrongful actions of an employee. It's like if a delivery driver crashes into your fence on the clock, the delivery company pays. In this case, the employer is the state, specifically the Minister of Safety and Security, and the employees are those 3 rogue cops. This is absolutely crucial to grasp if we want to understand who ultimately foots the bill when a state employee goes completely off the rails. Does the employer always pay, or are there limits? So Phoebus Apollo, the appellant, tried to use the Constitution to force the state's hand, and they came out swinging with 3 main arguments. First, they cited Section 25, arguing their constitutional property rights were violated by the state's agents. Second, they pointed to Section 205, subsection 3, which explicitly mandates that the police have a constitutional duty to protect the inhabitants of the republic and their property. And third, they relied heavily on a famous recent precedent known as the Shelley case. They argued that the court had previously developed the common law to hold the state liable when police fail in their constitutional duties, saying the police here clearly breached their duty to protect and recover the stolen property. And this brilliantly illustrates the dividing line in legal logic. The Constitutional Court looked at the appellant's reliance on the Carmichael precedent and drew a very sharp contrast. You see, in the Carmichael case, the court issue was wrongfulness. Did the police wrongfully fail in their duty to protect a citizen from foreseeable harm? But here, in the Phoebus Apollo case, wrongfulness isn't actually up for debate. Literally everyone agrees what the 3 cops did was horribly wrong. The issue here is purely liability. Who pays for that admitted wrongful theft? The court stated that the constitutional duties of the police didn't just magically stretch the boundaries of vicarious liability to cover an intentional, selfish crime.
The court was equally swift in dismissing the property rights argument under Section 25 of the Constitution. Here's the thing. Section 25 is designed to protect citizens from arbitrary governmental deprivation or expropriation. But the state didn't officially expropriate the aviation company's money. Armed robbers stole it first, and then 3 common thieves who just happened to be wearing police uniforms stole it again. The government itself didn't take the property, so the constitutional protection against government deprivation simply didn't apply to these facts.
This strips the entire case down to one fundamental strategic question. And I want you to play judge for a second and evaluate the true intentions of these corrupt officers. Were they acting as policemen, or were they pursuing their own selfish interests? Remember, they weren't assigned to the case. They had absolutely no official business being in Sinan. Yes, they had a police car and police badges, but were they actually performing police work?
Judge Kriegler, writing the unanimous judgment for the Constitutional Court, summed it up with incredibly vivid vocabulary. He wrote that cases like this require a nuanced weighing of the wrongdoer's subjective intention against the objective manifestations of their duties. Basically, he concluded that these cops, quote, deliberately set about creating a smokescreen of routine performance of their duties while actually pursuing their own different interests. The marked car, the badges, they were nothing more than a smokescreen. It was camouflage for a completely nefarious criminal scheme. They were never actually going about the business of the South African Police Service. Because they were acting entirely for themselves, the earlier decision by the Supreme Court of Appeal actually stood. The Constitutional Court ruled that the standard common law test for vicarious liability, which basically asks if the employee was acting within the course and scope of their employment, was already perfectly constitutionally sound. The aviation company admitted the law itself was fine, they just didn't like how the lower court applied the facts to that law. But, as Judge Kriegler pointed out, the Constitutional Court's jurisdiction is limited to constitutional matters. They can't simply reevaluate the facts of a case just because the outcome is rough. Therefore, the appeal had to be dismissed. The state was not liable.
But here is where the tone of the judgment really shifts, creating what we can call a sympathetic paradox. Judge Kriegler upheld the cold, hard boundaries of the law, for sure, but he went way out of his way to acknowledge a profound injustice. He validated the outrage that the aviation company, and frankly any of us looking at this, feels. The state legally won the case, yes, but morally, the system fundamentally failed the victim.
Judge Kriegler rapidly fired off the infuriating indignities the aviation company suffered at the hands of this completely bumbling and corrupt system. Just consider this cascade of failure. First, the robbery was an inside job enabled by treacherous security guards. Even though this was glaringly obvious, the police somehow delayed investigating the guards' home for 2 whole months. Even worse, the court noted unchallenged evidence that police actually searched the room where the guards hid the loot shortly after the robbery, but somehow completely missed the money hidden right under a mattress. Literally under a mattress. Then, 3 scoundrels, and that's the judge's exact word, used police resources to steal it. And when those cops were finally caught, the prosecution of these rotten apples was totally feckless, and the police took 0 effective steps to force them to return the ill-gotten gains. I mean, it is a staggering catalog of systemic failure. So the crucial point is this. Despite these horrifying, cascading systemic failures, the common law has to draw a line somewhere. The state cannot be held to a standard of absolute liability for every single independent crime committed by a rogue employee. When employees completely abandon their official duties from start to finish, solely to pursue their own selfish criminal gains, they are acting on their own. The state is an employer, sure, but it's not an absolute guarantor of its employees' morality when they go entirely off the clock and completely off the rails. However, the Constitutional Court did offer one final tiny gesture. Usually, the loser in a major legal battle has to pay the winner's legal costs, but Judge Kriegler stated that given how badly the criminal justice system had let the aviation company down, there was absolutely no warrant to penalize them further. The court dismissed the appeal but made no order as to costs. It was a small, almost microscopic concession for a massive betrayal by the state's agents. Which leaves us with this final thought to chew on. The logic of the Constitutional Court is sound. Vicarious liability absolutely must have limits. The law in this case was flawlessly upheld. But when you look at the whole sequence of betrayals, the missed evidence under the mattress, the rogue cops in a marked car, the lost money, was justice truly served? It's a tragic irony that perfectly illustrates the harsh and sometimes deeply unsatisfying boundaries of our legal system.
Thank you so much for joining me for this explainer. Keep questioning the structures around you, and I'll catch you in the next one.